Hello, everyone. Let's dive in. Clients and friends of the Carpenter Law Firm. Today, we're going to cover a challenging topic, neighbor versus neighbor issues. As long as humans have been on the planet, we have feuded with each other. Hey, let's go raid the other village. Hey, we're not getting along with people next door, even in the same village. And so, as long as we've been around, we have feuded with our neighbors. In fact, if you think about it, we don't particularly get along with people in our own families. And so let's talk about neighbor versus neighbor issues. And I mean that statistically and not about my own family necessarily. Let's talk about neighbor versus neighbor issues. We're in a webinar format today and it's being recorded. This webinar will be on my website once it's completed. And welcome your participation. There's a chat and a Q&A feature, and I intend to get through my content with plenty of time within an aspirational 59-minute format today. So let's talk about the rubrics of neighbor-to-neighbor issues. The old approach, which has been around since the 1970s. I'm not old enough to have been a community association lawyer in the 1970s. I started in 1994. You could do some simple math and guess my age if my gray hair doesn't betray me. So in the 1970s and forward, professional community management has essentially taken the position that's a neighbor versus neighbor issue. Leave it alone from an HOA perspective. And when I say HOA, I mean condos, townhouses, community associations. Generally, when there's a neighbor to neighbor dispute and someone comes to the board and says, my neighbor is harassing me or messing with me, do something about it. A common response from management or from the board is, quote, that's a neighbor versus neighbor issue. The HOA is not going to get involved. Leave it alone. And there has not been much criticism of that. In fact, it's been quite common. And as we go through today, you'll see why we call that the old approach. You could call it the old rubric. And perhaps still today, there remains remnants of this old pillar of professional community management. That's a neighbor versus neighbor issue. Leave it alone. And in a way, one could say it's also a pillar of what I call professional volunteer board service. Is there such a thing as professional volunteer board service? Well, of course not. Being a volunteer is the opposite to being a professional, that there are some board members who remain on boards for 5, 10, 15, 20 years. And along the way, one picks up some nuggets of wisdom. But this is not wisdom. This is the old approach from the 1970s forward. That's 50 years. And it has long been held that when neighbors feud, whatever it is, weeds or property line dispute or a tree in the backyard that's dropping clippings into one's pool, which is a neighbor versus neighbor dispute, of course, that volunteer board service, those that become professionals at it, would eventually say the HOA, the association, the condo, the townhouse, the planned community should not become involved because, wait for it, that's a neighbor versus neighbor issue. The association has no role to play. So this is what I call the old approach. Well, something happened and changed the old approach into the old approach. And that thing, well, let me just say, the old approach was easier. There's less friction, less fuss, as one's mom might say, stop fussing. There's less fuss for the association. If we can get away with it, this is easier for the association to wave our hands and say, nope, we're not involved. That's a neighbor versus neighbor issue. No friction for the association. We don't have to get involved. No legal fees, no problem. Go work it out amongst yourselves. And whatever you need to do to resolve your issue. I raised 3 daughters that are all adults now, married and have kids. And as a parent, it's easier to say to your feuding children, you go work it out. And so the temptation is easy and simple to say to feuding owners, like with your feuding children, you go work it out. I'm sitting on the couch. I've had a long day. I want to watch my program. And, whether it's the Suns letting another game slip away or the Suns winning another game, you go work it out. So the temptation is obvious. Go work it out amongst yourselves. The association, the parents don't want to get involved. Obviously, in human nature, this is the easier thing to do. So the old approach, when did it become the old approach? Well, I'm going to tell you. Here's the disruption. In December of 1997, there was a case in Washington, D.C., Reeves versus Carrollsburg Condominium Association. And at the time, it wasn't a big deal. It was not publicized that much, but it was an earthquake. And I'll tell you a little bit about it. Ms. Reeves, an African-American woman, sued her condominium for not doing enough about her neighbor, Mr. Shangala, a racist. And just for the sake of this discussion today, we'll concede that he was a raving racist. He was harassing her in a vile and racist manner. She alleged that he repeatedly yelled racist and sexist epithets at her, and that he prevented her from using the common areas of the condominium. He physically intimidated her, and he threatened to rape and kill her. These were all facts that were part of the case. What did she do? Well, she did what a lot of people do in this situation. She went to the association and said, he's doing all of these things, do something about it. And the association did nothing. The facts in the case are not perfectly clear, but the association took the old approach. That's a neighbor-to-neighbor issue. We, the association, cannot solve a neighbor-to-neighbor problem. She was a victim of what's called racial hostile housing harassment. If you have been part of workplace sexual harassment training, most of us have, there is an equivalent in housing, hostile housing harassment. And that's what she experienced. She's African American, it's a protected classification. And she alleged to the association that she was a victim of hostile housing harassment. And she went to the association, just like one in a workplace would go to their boss and say, I'm the victim of workplace sexual harassment. I'm in a protected classification, and you have an obligation to do something about it. She essentially went to her housing boss, the association, and said, I'm a victim of hostile housing harassment based on race. Here are the facts. Do something about it. HOA and the association did nothing. So the court held, after considering whether the condo association had a role to play, quote, in this case, the bylaws governed the association's actions. The bylaws authorized the association to address and curtail certain conduct that contravenes the law. In fact, any violation of local or federal law was likewise a violation of the association rules. So what the court did in Reeves v. Carrollsburg Condominium Association is acknowledged that when the governing documents, and here in Arizona, our governing documents often say that a violation of federal, state, or local law is a violation of the governing documents. We see these provisions often, that a violation of those statutes or laws is a violation of the governing documents. Then a violation of federal fair housing, which would include hostile housing harassment, but also be a violation of the governing documents, then the court found that it connected the dots here, that Mr. Shangala, by engaging in this activity, the 4 bullet points in the middle of the screen here, that he violated the governing documents of the Carrollsburg Condominium Association. And once he did that, he was an owner in violation. And the association had the ability to hold him as a violating owner. And the association could have helped Ms. Reeves. And its refusal to do so gave Ms. Reeves a viable legal claim against Carrollsburg Condominium Association, which is what she sued for. She sued Carrollsburg Condominium Association for doing nothing to protect her. And she won in 1997. So we, from that point forward, entered into a new approach. We had the old approach, which in fact, the Carrollsburg Condominium Association used the old approach in 1996, 1995, which is how the facts of the case worked. And so we ended up with this disruption to the old approach, where the court in Reeves v. Carrollsburg said Ms. Reeves had a claim against her association because it used the old approach. So let me just give you an example. Yesterday, I was flipping through some CC&Rs of a client. What do Arizona condo CC&Rs say? Similarly situated to Carrollsburg Condominium Association in Washington, D.C. Here's what I found. Somewhat common, and if you're watching this webinar from out of state, I have some clients in other states, and I know some people from out of state signed up. I'm happy to introduce this, but you'll find similar provisions in other states as well from Arizona. Section 4.11 from an Arizona Condominium Declaration, CC&Rs, no nuisance shall be permitted to exist or operate upon the condominium, and no activity shall be conducted upon the condominium which is offensive or detrimental to any portion of the condominium or any owner, lessee, or occupant, or which interferes with the quiet enjoyment of a unit by the owner, lessee, or occupant thereof. Now, Mr. Shangala intimidating Ms. Reeves, the case says that he also threw trash over their common wall. That certainly would interfere with her quiet enjoyment of the unit. No exterior speakers, horns, whistles, bells, or other sound devices shall be located, used, or placed on the condominium without the prior written approval of the board. The last sentence is not so important, but the quiet enjoyment in section 4.11 is important to the question. Let's go to the next section, lawful use. The court in Carrollsburg really centered on this provision, which the Carrollsburg Condominium Association, CC&Rs, had an equivalent to this provision. No immoral, improper, offensive, or unlawful use shall be made of any part of the condominium. All valid laws, zoning ordinances, and regulations of all governmental bodies having jurisdiction over the condominium shall be observed. Final sentence, most important. Any violation of such laws, zoning ordinances, or regulations shall be a violation of this declaration. So if an owner violates federal or state fair housing by harassing another owner based on a protected classification, then that owner is in violation of section 4.10. And the association may have a duty to stop the harassing conduct. And I'll show you in a minute what the federal government has done since Reeves v. Carrollsburg Condominium Association that prohibits the association from watching from a distance and essentially using the old approach let's let this work itself out and see what happens. That's the old approach. We can't just do that anymore. So the owners all have an obligation to follow the law all of the time. And if they don't, it's a violation of the CC&Rs. I've used this provision in a number of situations. A number of years ago, I had a client, it was a condominium, but it was more of a industrial condominium. And an owner was selling his unit. It was more of like an industrial park. And the buyer wanted to have a marijuana operation, grow and sell marijuana. Well, the other owners did not want that to happen. Well, it was legal under state law, and the city that this unit was in was fine with it, because Arizona has adopted a more permissive cultivation and sale statutory scheme. And the city was fine with it. And the state was fine with it. But as you probably know, the federal government still lists cannabis as a Schedule I narcotic. And the owners in this condo park, did not want this to go in from this new buyer. Well, I went to the CC&Rs. I found the equivalent of this provision right here. And I wrote a letter to the current owner / seller. And I said, time out. Before you get all excited and get a lawyer, and your buyer gets a lawyer, and you start thinking about your right to sell, and the buyer starts thinking about his rights under Arizona law to operate a marijuana facility under state law, let's remember that under federal law, marijuana is a Schedule I controlled substance, and it's illegal under federal law. And it is a valid law under the second sentence of section 4.10 on the screen. And remember, what I was using for that client was a similar provision to this. If your client sells to that buyer and they operate under their intended use, the association will file a lawsuit for an injunction to compel cessation of operation of a marijuana facility, because under section 4.10, that will be a violation of the CC&Rs because it violates federal law. And I bet you can guess what happened. The buyer floated away because the buyer understood you cannot operate a Schedule I drug cultivation and sale facility in a condominium with this type of provision, because marijuana is still a Schedule I controlled substance under federal law. And this type of provision makes that a violation of the CC&Rs. So I digress for a moment, but these provisions are incredibly important when they make any violation of law a violation of the CC&Rs. But I've mentioned it here for the sole purpose of pointing out neighbor-to-neighbor disputes under federal fair housing. So what's happened after Reeves? Not only are we off of the old approach, there is no such thing as, oh, it's just a neighbor-to-neighbor dispute. When a neighbor-to-neighbor complaint has occurred, rarely would an owner say, I'm being harassed based on a protected characteristic, do something about it. What they say is, I'm being harassed and we have to figure out what's going on. So in 2016, at the end of the Obama administration, at the very, very end, even after I think it might have been even after the 2016 election, or just before November of 2016. I can't remember exactly. It actually doesn't matter for what I'm saying. In 2016, there was a guidance from the Department of Housing and Urban Development, HUD guidance. And what the HUD guidance, it makes it harder for us, and I'll tell you why in a second. But before I tell you exactly what the HUD guidance says, and it's difficult, let's remember what the protected categories are under federal fair housing. Race, color, national origin. And when we talk about national origin, it could be that somebody says, I don't like you because you're Canadian. It could be, I don't like you because you're from Argentina. And it could be, I don't like you because you're from Poland. I don't want any people from Ukraine living here. Go back to where you came from. I don't want anybody living here who comes from Czechoslovakia. National origin is really I think one of the more challenging categories because it could be any country. We tend to think about discrimination based on white people being discriminatory toward darker skinned people, but national origin could be any nation. And it could be a nation full of lighter skinned people. But we have to be careful about that because you could have a white person who has a discriminatory attitude toward a country like Sweden. And you never really know why or how it could come up, but national origin is one of the trickier ones. Religion, I think this one's somewhat straightforward. We don't want anybody living here who worships that way or worships that God or whatever. Familial status, this one can be tricky too. We don't want anybody living here who has more than one spouse. We don't want anyone living here who has children. We don't want anyone living here who engages in polyamory, something like that. This one can be tricky, but familial status is usually one that we tend to think of it as one that refers to having children or not, children in the household, but it could be really anything about your familial status, whether you're married or not. This could be somewhat common. It could be as simple as something like that. Disability. Often in our world, in professional community management, we sometimes confuse the Americans with Disabilities Act and fair housing. The Americans with Disabilities Act was enacted in 1991 to deal with disabled people's access to places of public accommodation. Walmart, the Marriott, Target, stores, things like that, but not the clubhouse at your association. The disability in housing is under the Fair Housing Act. And so we have it here on purpose because the disability is a protected classification in housing, but the Americans with Disabilities Act rarely applies in housing unless your clubhouse is a place of public accommodation, which does happen every once in a while, but it's somewhat nuanced. Gender identity, this is somewhat new. There was a Supreme Court case a few years ago, the Bostock decision. I'm not going into detail here today, but one's gender identity is a protected classification in fair housing, in housing. And so if someone moves in next door and the owner says, my neighbor is harassing me because of my gender identity, they're picking on me constantly. Let's say Ms. Reeves identified as a man, but people think that she is a biological woman, and Shangala is, as we would say, a transphobe. And everything in that case that I highlighted earlier was really about him not being a racist, but him being a trans-hating transphobe, the facts and the outcome would be no different under the law today. If Ms. Reeves was what we would say had been a biological female, but had transitioned to male. Gender identity is protected, and this may be new to some of you. The gender identity is a protected classification. Sexual orientation is also protected, again, from that Bostock decision from the Supreme Court a few years ago. Under federal law, sexual orientation and gender identity were not included in the statute, but by case law have been included. So these are the protected category reminders that, and frankly, you sort of have to memorize them. You can make a cheat sheet for yourself, but when they come up, just don't be confused that if somebody comes to the board of directors and says, I'm being harassed by my neighbor because of, or I'm being harassed by my neighbor, we need to listen closely as to what may be going on because of what I'm about to tell you with the 2016 HUD guidance. So here's what the HUD guidance, and there's more to it than this, but what really got our attention in 2016 is that when the HUD guidance came out, there was some commentary that HUD provided, and we zeroed in on a few sentences, basically 3 sentences in the commentary that HUD sent out. And frankly, it suggested that HUD does not understand anything about our world. They don't understand community associations. They don't understand the leverage points, and they almost think that community associations are run like apartments where the association can evict people if they act up. And I'll show you what I mean here in a second. So this is verbatim from the HUD guidance. A community association generally has the power to respond to third-party harassment by imposing conditions authorized by the association's CC&Rs or by other legal authority. Okay, we'll concede that. So if we think about Ms. Reeves and Mr. Shangala, okay, Shangala is the third party, even though he's also a member. The association has the power to respond to Mr. Shangala's harassment by imposing conditions authorized by the association's CC&Rs and other legal authority. Okay, we'll concede that that's a true statement. Community associations regularly require residents, Shangala, to comply with CC&Rs and community rules through such mechanisms as notices of violation, threats of fines, and fines. Okay, so far so good. And this is the one, frankly, we couldn't believe this. HUD understands, underlining in bold is mine, HUD understands that community associations may not always have, they never have, may not always have the ability to deny a unit owner access to his or her dwelling. The rule, the guidance, merely requires the community association to take whatever actions it legally can take to end the harassing conduct. Now, there you go. That's the new approach. That's the new rubric. In 2016, HUD basically said the association has to end the harassing conduct. That's the new standard. When Ms. Reeves comes to the board and says, Mr. Shangala is harassing me, he's doing all of these things, the 4 bullet points, throwing trash over my wall, and he's vile, he's racist, he's the worst. Do something about it. The association's job now, under the HUD guidance, and HUD would say the law never changed. The fair housing law never changed. We just gave guidance about what has to happen. The association has to take whatever actions it legally can take to, in red, end the harassing conduct. And I've been at this 30 years. I can only chuckle every once in a while at the hubris, the arrogance. That's why I underlined and put in bold. HUD understands. It's just highlights that they don't understand. It's to highlight, we don't really understand, but we're going to say we understand. And then the words merely requires, they threw that in to basically say, we know that it's a lot. We merely require that you do whatever you have to end the harassing conduct. So that's the new standard, is end the harassing conduct. So the old rubric, it probably never worked. It probably was never supposed to work. If it worked, we got lucky because the fair housing statutes were always there. Ms. Reeves proved, and she had an advocacy organization that helped her in her lawsuit. If it worked, we got lucky because people didn't have the resources. They didn't have an advocacy organization that was helping them file a big lawsuit. And sometimes people get tired. They don't want to hire private attorneys, and they go on about their lives. Many people who are victims have other priorities. They've got family, they've got jobs. So the old rubric, if it ever worked, we got lucky. People just, had their own thing. But the old rubric wasn't supposed to work. It will no longer work. If there's good news, it's not really good news because there's a real victim in these scenarios, and I'm creating hypotheticals, of course. The protected category victims are generally unaware of these protections. Now, of course, I'm a lawyer. I've got HOA clients, and we don't want lawsuits. Excuse me. So it's good news when my clients are not sued. We don't want lawsuits. Insurance companies don't want claims. So we can say it's good news when protected category victims are generally unaware of these protections. So we'll take that for the moment. But there is free legal help for victims. The Civil Rights Division of the Attorney General's office, they bring these claims all the time. I'll give you an example of a claim I handled a number of years ago. There was a Hispanic woman who owned a home, a single family home, and she wanted to expand her driveway on the side yard. The short portion of the yard where the gate is, and she wanted to fill it in with concrete. She had a son that wanted to put a basketball hoop up, but in every Arizona single family home, the driveway cuts the yard, and there's a small piece of yard between the driveway and the rest of the lot on the short version. And she wanted to fill it in with concrete. Many people do it, of course, and don't know if she had an RV gate or not. If the RV gate is on that side, people do it so they can get their boat in their backyard or whatever. And the association said, you can fill in the side yard on the front up to the property line if you get your neighbor's permission. Well, she went to the neighbor, and the neighbor said, no, I do not want you to have a sea of concrete on your lot up to the property line on my side. Well, she was Hispanic. She went to the Civil Rights Division of the Attorney General's office. She represented herself, which really means the Attorney General's office represented her. They were her advocates. It went to a quick mediation. And at the mediation, I represented the association. And the mediation resulted in the neighbor, he wasn't necessarily racist, but what came out at the mediation was that the association conceded that, because it was the homeowner versus the association. Forget about the neighbor, he wasn't there. The association versus the young woman who wanted to expand her driveway, and the association were the only two parties at the mediation, now I remember. And the association conceded, my client conceded at the mediation, that if the sea of concrete that went up to the property line had been 6 inches in from the property line, she wouldn't have needed the neighbor's permission. But the allegation she made was that her neighbor was racist in denying the approval because she's Hispanic, and the Civil Rights Division kind of bought into it. But when the association conceded that the neighbor's permission wouldn't have been necessary if her request had been for the concrete to be within 6 inches of the property line, she wouldn't have needed his permission. This is where we get ourselves into trouble, is when we say to homeowners, you can do what you want on your property if you get your neighbor's permission. Because when we remove the association's decision-making and hand it to a neighbor, you can see that the association is asking the neighbor to be non-racist, to be non-judgmental, and to make a decision that has nothing to do with any of the protected categories. That's asking kind of a good bit. It's going to try to go back. Computer's not behaving to those protected categories. And that's asking a lot when the association essentially gives up its decision-making and hands it to a neighbor. We're talking about creating a neighbor-to-neighbor dispute. We shouldn't be doing that. If there's an architectural request before the association and the association says, well, you can probably do it, but get your neighbor's permission, we're creating neighbor-to-neighbor disputes. That's a bad idea. We shouldn't do that. If there's a decision to be made about a rear yard pergola or a property line issue or a rear yard whatever, make the decision. Don't punt the decision to the neighbor and introduce a neighbor-to-neighbor dispute where the neighbor could be an avowed anti-Canadian or an avowed anti-trans person or anti-LGBTQ plus person. And now we've introduced the possibility of a legal claim because the association, without needing to, created a bias and a claim where the owner who wanted to do a fair architectural item on their lot was shot down because the association gave up its decision-making authority when it didn't have to a neighbor who acted in a discriminatory manner under a protected classification. There's also free legal help for victims at HUD. There's free legal help for victims at various cities across the state through their civil rights offices. The Department of Real Estate has its dispute resolution process. I say they should care. Technically, under the statutory scheme, they should take these claims. I don't know if they would, or if the judges, the administrative law judges, would say it's beyond the purview of their charge or their jurisdiction. But technically, an administrative law judge under the Department of Real Estate process should have jurisdiction over these things. I'm not sure what they would do with it. I'm not sure we've ever seen one under federal or state fair housing. But also, also an owner who's a victim of a neighbor to neighbor dispute under a protected classification, a Ms. Reeves situation, could go straight to a county superior court. And if they wanted to, because there's a federal fair housing law, they could also go straight to federal district court, which seems a little strange perhaps. And I should have put that here. But there is no need to go to the Civil Rights Division, to HUD, to a city civil rights office. Someone could hire their own private attorney and file these claims straight in district court, federal district court, or an Arizona County Superior Court. These claims can be significant. There's a lot of money involved. Juries tend to award significant money damages to victims in these types of cases, especially if you go back to the story that Ms. Reeves was able to tell about how she was treated. Juries hate that kind of stuff. And the problem is, if you imagine that Mr. Shangala is, as we would say, an avid racist, let's assume he doesn't have a lot of money. He's not Jeff Bezos, he's not Mark Zuckerberg, he's not worth $10 million. He's a racist. And he doesn't have $10 million in a bank account that could be garnished easily. In fact, not a lot of people do, as it turns out. And so let's assume that the Mr. Shangalas of the world cannot be sued for $10 million easily. Who has the money? The association. So when the association is confronted by the victim, Ms. Reeves, in this hypothetical, just applicable to your situation or whatever comes up, the only entity with any money is the association and or the association's insurance carrier. So the only real target for the victim, Ms. Reeves, to get any money is the association. That's why we're so concerned about it. So what we have to do when something comes up is we have to have an action plan. What is it? If someone says my neighbor is messing with me and harassing me, we have to investigate and take action with the goal of ending the harassing conduct. Neutrality is not going to work anymore. If it ever did, like I said, if it did, we got lucky. We have to investigate and we have to figure out what is going on. The investigation can be done. We've just got to figure out what's really going on. We've got to figure out, is Ms. Reeves making it up? Is Mr. Shangala truly doing these things? I keep going back to that because that's the scenario we talked about. But neutrality, make them work it out on their own, is not going to work. We have to take sides, got to figure it out. And that's the action plan going forward. We have a few minutes for questions in a webinar format. It has to be done in the Q&A or the chat, and I'm happy to attempt to answer questions either in the chat or the Q&A. Yes, I see two questions. Katie, a threat of killing and rape would be a police matter. And I agree with you that it should be a police matter, absolutely. It's not mutually exclusive, though, with treating it as hostile housing harassment. I think that, the victim of that kind of threat might still consider it to be a hostile housing harassment. I wouldn't necessarily consider the association's hands clean if the police don't haul the person off and put them in jail. I think it still has to be treated as hostile housing harassment. Deborah raises a really good question. What if neither party is a protected status? If neither party is a protected status, victim or perpetrator, then we don't really have to worry too much about hostile housing harassment. Two middle-aged white guys like me getting in a war in the cul-de-sac, and one or both of us come to the association and say, my neighbor's harassing me, do something about it. That's a tricky one, because if neither one of us can be victim in a hostile housing situation, hostile housing harassment situation, because neither one of us are in a protected classification, the association gets out from underneath the hostile housing harassment problem, because the obligation and the harassing conduct centers, Deborah, on one or both of us. Both is weird, of course, but one of us being in a protected classification. One of the problems is that there are classifications that a person wouldn't know about unless I self-identify. For example, sexual orientation. I have to say that, or you wouldn't know it. You can't tell by looking at someone that they're gay, for example. I'd have to tell you. And so some of those classifications are tricky because gay people don't have a big G on their forehead to identify themselves as gay. And so some of them are tricky and you wouldn't know unless I tell you. Leisha asked, what are your thoughts on two homeowners consistently filing homeowner complaints about each other? Consistently has nothing to do with it, but two homeowners filing complaints about each other, the frequency is something you have to sift through, because Ms. Reeves and Mr. Shangala could have been back and forth with each other constantly, but wouldn't have changed the fact that Ms. Reeves was the true victim. I think you have to investigate. The frequency really has nothing to do with it. And that's what makes it so tricky, is that you really have to do the investigation and figure out what's really going on. HUD wants the association to end the harassing conduct. Frequency, unfortunately, isn't going to be a defense to why didn't the association figure this out and end the harassing conduct. Randy, what should the HOA have done to end the harassing? Fines will work if they're effective. Fines are good enough if they're effective, but what I find so troubling about HUD's sentence is they're essentially saying, do whatever you need to end the harassing conduct. So what the association should have done is whatever was effective. And that's why we struggle with these situations. Is it's kind of like, I'm going to use a silly example from high school algebra, calculus probably. If you jump halfway to the wall, and every time you jump halfway to the wall, you'll never get there. It's called an asymptote. It's asymptotic. And Randy's question makes me think of that silly example from high school, is what should the association have done to end the harassing conduct? Well, jump halfway to the wall, and then jump halfway to the wall, and then jump halfway to the wall. Well, what HUD wants is don't jump halfway to the wall, jump all the way to the wall, get there and end the harassing conduct. Don't just keep doing half measures, get there, whatever that might be. And unfortunately, with the skyrocketing inflationary nature of legal fees, fines might not work. Might have to sue Mr. Shangala in Superior Court to get an injunction to get his attention. And that would be expensive, but it might be cheaper in the long run than what the association had to pay to Ms. Reeves for not doing anything about Mr. Shangala, which is kind of full circle to the conversation. Sierra asks, if something is determined to be a neighbor-to-neighbor dispute, what is the best way to approach the owners? Let them know it must be handled between them. The association is responsible, from what it sounds like, the association is for taking action on every complaint. I don't know that the association is responsible for taking action on every complaint. What I'm suggesting is the association can't afford to make a snap judgment at the beginning that every neighbor-to-neighbor complaint can be dismissed as you guys go work it out. Like my temptation when my kids were younger, go work it out, I'm busy. The association has to do enough investigation to figure out that perhaps nobody's in a protected classification, or maybe there is something here. And in some cases, you can tell people the association has no role to play here, go work it out, or here's a mediation service that perhaps you can use. There are some of those, but I think at the end of the day, the association has to be involved enough to figure out if there's hostile housing harassment, someone's protected, someone's the harasser. Association has to figure out if it can end the harassing conduct. I didn't know you could be an anonymous attendee, Mr. or Ms. Anonymous. We use complaint forms to address neighbor-to-neighbor issues, but if we get multiple from one owner, what is the best practice if we suspect they are not valid? Complaint forms make sense. I think, the same rules apply. Eventually, the issue is that if there's someone who is a victim and someone who's a harasser, once the association determines that the harasser is truly a harasser, then the association must take action to end the harassing conduct. If there's a complaint that's not valid, I'm not so concerned about that. I'm concerned about the harasser being on the receiving end of action from the association to comply with the HUD guidance. That's the more important thing. I'm not sure that it's that important to weed out an invalid complaint. The attention should be on the harasser, not so much on an invalid complaint. I think that's placing attention on the wrong thing. And then Leisha, let me go back to the original. What, 2 homeowners consistently filing homeowner complaints and then a follow-up. They each appeal the complaint. It goes on week after week. Well, I would suspect that with 2 people who are kind of at each other all the time, this is where a good investigative process would be helpful to all involved, where if they're just constantly at each other and in addition, constantly expecting the association to solve the problem, a good investigatory framework would be good, where the association could roll up its sleeves corporately, so to speak, figure out if it could what's really going on, take a side and move forward and say we're on Ms. Reeves' side or we're on Mr. Shangala's side, and using that framework again back to where we started, and try to abandon neutrality because that's what gets us into trouble. When I say to my kids, go work it out, I'm attempting to take a position of neutrality. And from my kids' perspective, it's frustrating. And perhaps they consider it to be disrespectful. And it's not helping in this situation, Leisha, I suspect, because they keep coming back, they keep expecting, it's that definition of insanity, doing the same thing over and over and expecting a different result. They may feel that that's what's happening here, is that they keep coming back week after week and expecting something different to happen. Perhaps an investigation, separate interviews, and a site visit, whatever really is going on, and digging in a little deeper, and then have the board pick a side and, you know, come out of this with, we are on the side of Ms. Reeves, we're on the side of Mr. Shangala, whatever it might be, and then try to move forward. Having picked a side might be better, because that's really what HUD wants. End the harassing conduct after an investigation, and then move forward that way. All right, my goal was a 59-minute bring your own lunch. I don't know if you got that part. We did this from noon to 1 Arizona time. If you're in another part of the country, perhaps you were able to enjoy a snack. And thank you all for joining me today. This was Neighbor versus Neighbor, a refresher from the old approach to the new approach. Thank you all for joining me today, and hope you all have a great rest of the day and a great rest of the week. Thanks.